Hello everyone, I am George.
Hi everyone, I am Amy. Today, we will be discussing the meaning and concept of repugnancy.
However, before discussing the concept of doctrine of repugnancy, let's understand first the meaning of repugnancy. The simple English meaning of repugnancy is inconsistency or incompatibility of ideas or statements.
In addition to this, we need to discuss one more point before coming to doctrine of repugnancy, that is, Article 254 of the Indian Constitution. Article 254, 1, describes the inconsistency between laws made by Parliament and laws made by the state legislature.
It can be read as, if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then, subject to the provisions of Clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or, as the case may be, the existing law, shall prevail, and the law made by the legislature of the state shall, to the extent of the repugnancy, be void.
Don't get confused because of lengthy explanation. It is simply saying that any subject enlisted in concurrent list, if it is legislated by Parliament, then it will prevail irrespective of the fact that the state legislature made the law before the Parliament. So, in this case, before or after does not matter, rather parliamentary legislation will prevail.
However, Clause 2 of Article 254 gives some relief, as where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then, the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in that state.
But don't get happy because this provision is not an independent, rather condition is applied, that is, provided that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying or repealing the law so made by the legislature of the state.
Anyway, come back to our topic, that is doctrine of repugnancy. It means that if there is any inconsistency between the law made by Parliament and the law made by the state legislature, specifically in reference to concurrent list, then to check the validity, doctrine of repugnancy will be applied.
However, if any one of you still have any confusion regarding the concept of doctrine of repugnancy, you may ask through the comment box given below.